Hi again and welcome back. Attorney Steve Vondran here. Welcome to another exciting episode of Copyright Watchdog. Okay, so in this video we are talking about the legal requirements to file a DMCA takedown notice. Now this is when you see somebody on your YouTube or on their website, basically showing your copyrighted images or your music or your photos, and you say, you know what, that's wrong. That needs to come down, that video needs to come down, or that photo needs to come down. Sometimes you need to send your letter, your DMCA takedown notice, to websites like Twitter or Facebook, these sites that host all these photos. So those sites are usually not liable for any copyright infringement if they have a DMCA takedown notice procedure in place. And most of the big companies will, like YouTube. And this is getting bigger and bigger. I'm seeing more and more of this. People getting false takedown notices, people that do not have the rights to a photo or video or music, issuing takedown notices. Now there's a requirement right here. This is off my blog, vondranlegal.com. And you can see here there are certain requirements if you want to comply with the law and issue a valid DMCA takedown notice. You want to be issuing these notices only in good faith. Okay, if you're not doing this in good faith, taking down somebody's channel, it leads to an account takedown on YouTube, that could be considered bad faith. So here's the requirements. Very simple. Number one, a physical, and this is 17 U.S.C. 512 C3, C is in Charlie 3, okay? 1, there must be a physical or electronic signature of a person. You know what? I'm going to let my friend read this here, so hang on a second here.
A physical or electronic signature of a person authorized to act on behalf of the owner of an exclusive right that is allegedly infringed. 2. Identification of the copyrighted work claimed to have been infringed, or, if multiple copyrighted works at a single online site are covered by a single notification, a representative list of such works at that site. 3. Identification of the material that is claimed to be infringing or to be the subject of infringing activity and that is to be removed or access to which is to be disabled, and information reasonably sufficient to permit the service provider to locate the material. IV. Information reasonably sufficient to permit the service provider to contact the complaining party, such as an address, telephone number, and, if available, an electronic mail address at which the complaining party may be contacted. V. A statement that the complaining party has a good faith belief that use of the material in the manner complained of is not authorized by the copyright owner, its agent, or the law. V. A statement that the information in the notification is accurate, and under penalty of perjury, that the complaining party is authorized to act on behalf of the owner of an exclusive right that is allegedly infringed.
Okay, so there you have the requirements. So these requirements must each be met in order for the DMCA takedown notice to be valid. Now, sometimes on YouTube side, they're going to go ahead and just process a claim, but they're not going to know, for example, if you're the person who's submitting the claim is actually the copyright holder or their authorized agent. And if somebody's just issuing takedown notices, they are not the owner or the agent, that's a problem because you're not complying with the statute. So there is a thing known as the 512F claim, F as in Frankfurter, the 512F claim, and I'm going to talk about that in another video, but these are the general requirements to file a valid DMCA notice. If somebody is cutting corners, then you may have a claim, okay? Attorney Steve, if you need help with copyright, DMCA, internet law, let us know. Civil litigation, you can find us on the web at attorneysteve.com. That's attorneysteve.com, the first name in legal services. Make sure to subscribe if you have any comments. Put them down below. Have a great holiday season. We'll talk to you soon.